We're on the record in cause number 328786. The case is styled the state of Texas versus Jesse Wyland, Jesse Wayland Bertram. Mr. Bertram, would you please raise your right hand? Mr. Bertram, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Okay, you may put your hand down. How you doing, Mr. Bertram?
I mean, it's another blessed day. God woke me up this morning, sir.
Oh, that's a good thing. It's another day that the Lord has made. Let us rejoice and be glad in it.
Yes, sir.
Okay, Mr. Buttram, the information in your case alleges that on or about January 1st of 2021, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Buttram, do you understand what you've been charged with?
Oh, yes, sir.
And to this charge, Mr. Buttram, how do you plead? Guilty, not guilty, or no contest?
Guilty, sir.
Now, you're pleading guilty freely and voluntarily?
Absolutely, sir.
And are you pleading guilty because you are guilty? Mr. Buttram, are you pleading guilty because you're guilty?
Because I what, sir?
Are you pleading guilty because you are guilty?
Yes, sir.
Mr. Buttram, I have before me a document that is titled the Misdemeanor Plea Admonishments. It is also labeled as State's Exhibit Number 1. On page 2 of this document, there are a set of initials, JB, that is on a line next to a box that says check guilty. Did you place your initials on this document?
Yes, sir.
And on page 3 of this same document, there's a signature above the line that says defendant that purports to be listed. Is that your signature?
Yes, sir.
And I have another document here. This document is titled Trial Court Certification of Defendant's Right of Appeal. There's a signature above the line that says defendant. Is that your signature?
Yes, sir.
And there's one box that's checked at the top of this document. That box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
Mr. Buttram, did you sign a document out there that was titled, or that is titled, the Discovery Certification?
Yes, sir.
Now, prior to signing and initialing all of these documents that I just spoke of, did your attorney, Mr. Matuska, who is there with you, did he go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Absolutely, sir.
State, I have before me State's Exhibit Number 1. State, you like to offer State's 1?
Yes, Your Honor.
Mr. Matuska, do you have any objections?
No objection, Your Honor.
Okay, no objections. State's Exhibit Number 1 will be admitted. Mr. Matuska, you have advised and counseled Mr. Buttram. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Buttram, your attorney, Mr. Matuska, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Absolutely, sir.
Mr. Buttram, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers was freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor. It's for 30 days county jail.
Mr. Buttram, the state is offering that you serve 30 days in the Jefferson County Jail. Mr. Buttram, you will be given credit for any time that you are entitled to get by law in this case. Mr. Buttram, you'll also be required to pay court costs of $327. Mr. Buttram, will you be able to pay the court costs of $327?
I mean, as of right now, Your Honor, I mean, if it's mandatory for me to pay this surcharge,
Okay, Mr. Buttram, this is court costs. The court is just asking you whether or not you'll be able to pay the court costs of $327.
I mean, I'm homeless right now, sir. I mean,
okay. Now, Mr. Buttram, you stated that you're homeless. Is that correct?
yes, sir.
And so, are you married, single, divorced, separated? What is your marital status?
I'm single, sir.
Okay. Now, do you receive any type of governmental assistance? Medicaid?
No, sir.
Receive SSI?
No, sir.
SNAP?
No, sir.
TANF?
No, I don't get any type of government assistance whatsoever, sir.
Okay. And do you have any other form of income?
No, none whatsoever, sir, right now.
Okay. Now, and you said you're homeless, you know, are you ordered to pay any child support or anything?
No, sir.
And now food expenses, is someone else providing that for you?
I didn't hear what you said, sir.
Is somebody else providing your food expenses for you?
Sir, I literally like sleep between Target and IMART in front of the Parkdale Mall. I mean, and before I came, I mean, if you look at my identification.
Mr. Buttram, I'm just asking, do you have any food expenses? Yes or no?
I mean, everybody has to eat every day, but I mean, I'm homeless and people give me money, sir.
Okay, so people are,
I mean, they buy me food and give me money, sir. I mean,
that's what I'm getting at.
Yes, sir.
I don't know the answer to that. That's why I'm asking you the question.
Oh, yes, sir. I mean, people are nice people. I mean, before I shaved the giant beard off, I mean, I looked like Jesus. So, I mean, people kind of blessed me abundantly.
Okay, so so people just would provide the food for you. Is that correct?
Absolutely, sir.
Okay, now what about, you don't have transportation, right?
No, sir. I catch the BMT, the Beaumont Transportation, Metropolitan Transportation, sir.
Okay.
Transient transportation.
Okay. Now, you're not, are you paying any probation fees or anything?
No, sir.
Okay, and any medical expenses that you're paying?
No, sir.
And no credit card expenses, is that correct?
No, sir.
Okay, so the court is going to find that you are indigent, and based on the court's finding that you are indigent, the court costs in this case will be waived pursuant to Article 42.15 of the Texas Code of Criminal Procedure. So, Mr. Buntram, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Absolutely, sir.
Okay, so Mr. Buttram, you've sentenced to 30 days in Jefferson County Jail. You'll be given credit for any time that you're entitled to get by law. The court cost in this case is going to be waived because the court has found you to be indigent. Mr. Buttram, this will conclude your case. Please follow the bailiff and you have a blessed day.
God bless you.
Right,
Thank you, Mrs. Ramos.
Just knock on that door and the bailiff will come and get you.
Okay. God bless you, sir. Thank you.
All right. God bless you as well.
Thank you.
Thank you, sir.
That's a good deal. All right. Mr. Galvan, you're up.
Your Honor, this is Mr. Galvan, and I've signed on the tablet on his case, and I'm ready whenever you are.
We on the record in two cases. The first case is cause number 320146, and the second case is cause number 327286. Both cases are styled the state of Texas versus Juan David Galvan.
I think the door by Mr. Galvan might be open. It looks like I'm having trouble hearing.
Okay, is it closed? Okay, Mr. Galvan, did you hear that, or would you like me to repeat it?
No, sir, I can't hear you.
Okay. We on the record in cause number 320146 and cause number 327286. Both cases are styled the state of Texas versus Juan David Galvan.
Right.
Mr. Galvan, would you please raise your right hand? Mr. Galvan, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Okay, Mr. Galvan, you may put your hand down. Mr. Galvan, how are you doing this morning?
Good, good. How about you?
I'm doing fine. Thanks for asking. Mr. Galvan, the first case that I have before me, Mr. Galvan, is a motion to revoke your probation. This motion alleges that on March 20th of 2019, that you were found guilty for the Class B misdemeanor offense of driving while intoxicated. You were sentenced to 90 days confinement in the Jefferson County Jail, a fine of $750. And that fine and your sentence was probated for 1 year. The state on March 18 of 2020 filed a motion to revoke your probation. In this motion, there are several allegations. Oh, this is signed. Okay.
Your Honor, I'm
looking at the.
realize that this is a motion to revoke, and I think when we signed them up on the tablet, we might have signed it wrong.
Yeah, I see that. I could give you. I'm gonna get out of the document to give you time to make the corrections.
Okay.
Mr. Galvan, just hold on. Some corrections need to be made.
Sir, I can't hear you.
I say just hold on. Some corrections need to be made on your paperwork.
Yes, sir.
Okay, so just hold on for a few minutes.
Yes, sir. I have no idea. I have no idea.
Hey, Peppo, is the bailiff in the room with you?
I'm right here.
Hey, Peppo, I'm going to save this. He needs to open back up the 320 clause number. He signed under guilty, and this is a MTRP.
All right, I'm sorry.
I put the allegations on there.
I see that, baby, and I didn't. I'm sorry.
No, it's okay. I missed it too.
I've even got it highlighted. Okay. Okay, I got to get a tablet from the lady. Okay, thank you.
That's okay. You got it? All right.
Hey, Ashley.
Yes.
Also, it's not a Class B misdemeanor. On the page 1, I got to move it down to the MTRP line.
Yes.
On page 1. Okay, I'm going to check off MTRP, taking it off a Class B misdemeanor, putting it down on the MTRP. Okay. Yeah. See, and you're on guilty. You got to sign it. Put your initials right there on that. Okay, we've got it all checked, right? Yeah.
Y'all ready?
We're ready.
Okay. We're back on the record in cause number 320146. Case is styled the state of Texas versus Juan David Galvan. Mr. Galvan, I have a motion to revoke your probation. This motion alleges that on or about March 20 to 2019, that you were found guilty for the offense of driving while intoxicated, and your punishment was assessed at 90 days confinement in Jefferson County Jail, a $750 fine, and your sentence was probated for 1 year. In this motion that was filed by the district attorney's office on March 18 of 2020, the first allegation alleges that you committed the offense.
Your Honor.
Yes.
I'm sorry, the state's going to go ahead and abandon count 1.
Okay.
And then I believe he's going to plead to counts 2 and 3.
Okay. The state is abandoning count 1 in this motion, so we'll proceed to count 2. Count 2 alleges, Mr. Galvan, that you failed to abstain from the use or possession of any drugs except those taken or possessed under doctor's orders as ordered by the court, in that on about March 10th of 2020, that you provided a urine sample for a scientific analysis that showed the presence of the metabolic byproducts of tetrahydrocannabinol in violation of condition 12 of your probation order. Mr. Galvan, is that true or not true?
True.
Allegation 3 alleges that you failed to perform community service hours required as ordered by the court in violation of condition 18 of your probation order. Is that true or not true?
True.
Are you pleading true to allegations 2 and 3 freely and voluntarily?
Yes, sir.
And are you pleading true because they are true?
True.
Mr. Galvan, I have before me a document that is labeled State's Exhibit number 1, and it's titled the Misdemeanor Plea Admonishments. On page 1 of this document, the box checked is MTRP, which stands for Motion to Revoke Probation. On page 2 of this same document, there are some initials on a line next to the box that's checked MTRP, true to allegations 2 and 3. Did you place your initials on this document?
Yes, sir.
Then at the bottom of this document, below the paragraph that is titled Discovery Admonishment, there are some initials on a line that say, I do not request discovery of an evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Are these your initials? Well, Mr. Galvan, on this line, I will make an adjustment. I'll change plea of guilty or no contest to a plea of true. Okay, because this is a motion to revoke probation. Now, are these your initials on this document?
Yes, sir.
And do you understand the change that I've made to this document?
Yes, sir.
Okay. And Mr. Galvan, on page 3 of this same document, there's a signature above the line that says defendant. That signature purport to be your signature. Is that your signature?
Yes, sir.
Now, Mr. Galvan, on the next document is titled Trial Court Certification of Defendant's Right of Appeal. Mr. Galvan, there's a signature above the line that says defendant.
Yes, sir.
Is that your signature?
Yes, sir.
I also have, Mr. Galvan, at the top of this document, a box that is checked that states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
Mr. Galvan, before you signed and initialed these documents, did you have an opportunity to read these documents?
Yes, sir.
And did you read the documents?
Yes, sir.
Okay, did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit number 1. State, you like to offer State's 1?
Yes, Your Honor.
Mr. Galvan, the state is offering State's Exhibit number 1 to be used against you as evidence in this case. State's Exhibit number 1 is a document that have your initials on page 2 and your signature on page 3. Is it all right for the state to use this document as evidence against you in this case?
Yes, sir.
Okay, Mr. Galvan. No objection, State's Exhibit number 1 will be admitted. Mr. Galvan, is there any evidence that you are currently mentally incompetent to stand trial?
Can you repeat yourself again, please?
Is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Okay, Mr. Galvan, I will accept your plea of true to allegations 2 and 3. I will also find that you are mentally competent to stand trial. I will also find that your plea of true and your waivers were freely and voluntarily given. I will also find that there is sufficient evidence to revoke your probation and your probation is revoked.
Yes, sir.
Mr. Galvan, well, state, do we have a plea bargain agreement?
Yes, Your Honor. It's for 90 days credit for time served, tax and retire of the court cost.
Mr. Galvan, the state is offering that you serve 90 days in the Jefferson County Jail. However, you would not have to serve 90 days in the Jefferson County Jail in this case because you've already served 90 days in the Jefferson County Jail. Therefore, you'll be given credit for time served.
Yes, sir.
Now the court cost in this case is $117, but you will not have to pay that court cost because the time that you spent in jail has already paid it off.
Yes,
therefore, the court costs will be taxed and retired. Mr. Galvan, do you understand the state's offer? Do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Galvan, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Galvan, you have another case. This case is cause number 327286. And in this case, Mr. Galvan, the information alleges that on or about July 3rd of 2020, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest detention. Mr. Galvan, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Galvan, how do you plead? Guilty, not guilty, no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charge?
Yes, sir.
Mr. Galvan, I have before me a document that is titled the trial court certification. Excuse me. I have before me the document that is titled the misdemeanor plea admonishments. In this document, Mr. Galvan, on page 1 of this document, there's one box that's checked, and that box states that this is a Class A misdemeanor. On the second page of this document, there are a set of initials. The first set of initials is on a line next to a box that says guilty. And the second set of initials is below a paragraph that reads discovery admonishment, and it is on a line next to the line that states, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Mr. Galvan, are these your initials on these lines?
Yes, sir.
And on page 3 of the same document, there's a signature above the line that says defendant. Is that your signature?
Yes, sir.
And on the next document, Mr. Galvan, this document is titled the trial court certification of defendant's right of appeal. There's a signature above the line that says defendant. Is that your signature?
Yes, sir.
And there's one box that's checked. This box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
Now, prior to signing and initialing these documents, did you have an opportunity to read the documents?
Yes, sir.
And did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents, Mr. Galvan, true and correct to the best of your knowledge?
Yes, sir.
State, I have before me state's exhibit number 1. State, you like to offer state's 1?
Yes, Your Honor.
And no objection to state's exhibit number 1. Well, Mr. Galvan, let me back up. Mr. Galvan, the state is offering state's exhibit number 1. State's exhibit number 1 is a document that have your initials on page 2 and your signature on page 3. The state would like to use this document as evidence against you in your case. Is it all right for the state to use this document as evidence against you in this case?
Yes, sir.
Okay. Now, okay, no objections to state's exhibit 1. Now, Mr. Galvan, I'll just back up. Did you enter a plea of guilty or did you enter a plea of no contest to this?
Guilty.
You entered a plea of guilty. All right.
No, he marked guilty on the paperwork.
Yeah, I did guilty.
Because
Okay, that's why I was trying to get it correct. I thought he said no contest.
Yes, sir.
So your intent is to plead guilty. Is that correct?
Yes, sir.
Okay. Okay. Now, Mr. Let's see.
That's on 327286.
327286. Yes. Okay, Mr. Galvan. Is there any evidence that you're currently mentally incompetent to stand trial in this case?
No, sir.
Okay, Mr. Galvan, I would accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Mr. Galvan. Well, now, Mr. Galvan, you pleading guilty because you're actually guilty. Is that correct?
Yes, sir.
And your plea of guilty is freely and voluntarily given. Is that correct?
Yes, sir.
Okay, so Mr. Galvan, I will find that your pleas and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor. It's for 90 days credit for time served, tax, and retire of the court cost.
Okay, Mr. Galvan, the state is offering that you serve 90 days in the Jefferson County Jail. However, you would not have to serve 90 days in the Jefferson County Jail because you've already served 90 days in Jefferson County Jail in this case, and therefore you'll be given credit for time served.
Yes, sir.
Now, the court cost in this case is $342, but you would not have to pay the $342 because you've already served enough time in this case. Therefore, the court costs will be taxed and retired. Mr. Galvan, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Galvan, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Galvan, you can have please follow the bailiff on your way out, and you have a blessed day.
You too, boss man.
All right, you are excused.
Yes, sir. Thank you.
Okay.
Are you done? Good deal. Wait till she comes back. Yeah, wait till she comes back. I can't see you back. I don't work out here. Oh, no.
Are you Eugene Odom?
Yes, ma'am.
Okay, the judge will be on in just a moment.
Okay.
We're on the record in cause number 328656, and the case is styled the State of Texas versus Eugene Marvin Odoms. Mr. Odoms, would you please raise your right hand? Mr. Odoms,
Yes, sir.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Odoms, you may put your hand down. How are you doing, Mr. Odoms?
I'm doing great, sir.
That's good, Mr. Odoms. As a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Do you understand that option?
Yes, sir.
Number two, if you do not have enough money to hire an attorney, you may request an attorney to be appointed to represent you. Do you understand that option?
Yes, sir.
Or number three, you may represent yourself. Do you understand that option?
Yes, sir.
If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Do you understand that?
Yes.
If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Do you understand that option?
Yes, sir.
Now, Mr. Oldham, you'll have three options. If you want to hire an attorney, your case will be reset. Or if you've already hired an attorney, that attorney will be contacted and given you a reset date. Or if you want to apply for court-appointed counsel, you would have to fill out a financial questionnaire. Or if you've already have been appointed a court-appointed counsel, we will contact that attorney and your attorney will be given your reset date. Or if you want to waive your right to an attorney and represent yourself, you will please inform the court. Now, Mr. Oldham, do you want to hire an attorney, or do you want to see if you qualify for a court-appointed attorney, or do you want to waive your right to an attorney and represent yourself?
I want to waive my rights to represent myself.
Okay, now, Mr. Oldham, before you can talk to the prosecutor, you would have to sign a written waiver of your right to be represented by an attorney. I will read to you the waiver of counsel that is included in State's Exhibit number 1 under the paragraph called waivers, and it reads as follows. I have been advised this day by the court of my right to representation by counsel in the case pending against me. I have been advised and understand that if I am determined to be indigent, counsel will be appointed to me free of charge. Understanding my right to have counsel appointed to me free of charge if I am found to be indigent, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I specifically waive my right to be represented by an attorney, to consult with an attorney before I give up these enumerated rights. It is my decision to represent myself, and I do so knowing the dangers and disadvantages of self-representation. I further elect not to request appointment of counsel. Mr. Oldham, is that your desire?
Yes.
Okay, now, Mr. Oldham, you'll be given an opportunity to talk to the prosecutor about your case.